Hello, this is a presentation by Family First Legal. This presentation will cover custody modification in Maryland. By the time we end this presentation, you should expect to understand modifications generally, the standards that are required by the court in order for you to receive or for you to get denied a modification, and then some other considerations for you to take into account as you decide whether to defend against or whether to file your custody modification. Modifications are generally always possible when it relates to children. In Maryland, either parent or either party who was involved in the prior order or an intervening party who now seeks to modify the previous order may file with the court for a modification. However, whoever the party is who is filing for the modification, they must be able to show the court that the standards the court rely on for modifications have been met. Those standards for custody modification are substantial or material change and best interest. So we'll start with substantial and material change because best interest is required in all custody cases, including the initial filing of the case, as well as whenever it's between parents who are both custodians of the child but are seeking a court order. Best interest is always going to be the central standard. So we'll briefly review best interest, but best interest standard has been reviewed in one of the other modules or presentations regarding parental custody. We'll focus here mainly on the substantial and material change standards. So the substantial or material change means that there has been a change in the circumstances such that the court would consider it substantial enough to have changed the best interest of the child since the prior order. In other words, something has happened that has changed the status quo, that has now placed the child in a position where the child is not being served at the level he or she was being served before. As far as financially, they're in a different position. Educationally, they're in a different position. The parents are in a different position. We found out more information about them, which would impact the child. So there's a lot of things that you can look at as far as a change in circumstances. However, it can't be a minor change in circumstances. So even if there is a disagreement between parties who have custody of a child or who share custody in visitation for a child, that disagreement may not be enough or sufficient to be a substantial or material change. An example of one such disagreement might be a disagreement about the type of clothing a child wears. The court may not see that as a substantial or material change. But if you're talking about what religion the child will be involved in, worship, or if we're talking about educational needs of the child and what type of educational resources will be available to the child, that may be seen as a substantial or material change. So when you're going into court for a material change, you have to ask yourself, was this thing in place at the time that the prior order was made? If so, then that's not a material change because it's not something that has changed between the last order and your current request for modification. And then if you meet the standard for substantial or material change for modification, you will then need to address the best interest standard. So whatever you're asking the court to do, you're saying, okay, there was a substantial change. You've identified that sufficiently to the court. Now the court is wanting to know, what is it you're asking us to do based on that substantial change? And is what you're asking us to do or what you're asking the court to do in the best interest of the child? So there are going to be some factors that the court looks at. So no one factor would be conclusive, but you want to have multiple of the factors checked off. I've covered these factors in great detail in some of the other modules, including the parenting module. But you can see here on the screen, the change being requested must be in the best interest of the child, and that those same factors that apply to parents in the best interest situation are the factors the court will look to here. So an example of those types of factors will include the health of the parents, the financial needs of the child, whether the child has any kind of different needs or educational needs that are being met or left unmet, things like that. So there are some other considerations besides the standard. So we just reviewed the two standards the court will look at when you're asking for a modification, that substantial change and the best interest standard. But then you also have to think about the preference of the court. The court's preference, anytime you're filing for a modification, is to keep the status quo. And what that means that if the court has already entered a prior judgment, the court believes that they entered that judgment in the best interest of the child. Therefore, the court wants to keep that order unless you can show and meet those standards, which we discussed earlier, to show the court that there is such a substantial change that something is necessary to be modified about the order, and the modification that's being requested is in fact in the best interest of the child. But you do have to keep in mind, if you're just changing the order just to be changing it, you're thinking you didn't get what you wanted last time, I'm filing for a modification to get what I want this time. If you're filing on the same facts, you're probably not going to get a modification. So keep in mind, the court will look to that best interest standard and think that they've already met the best interest standard in the prior ruling, in the prior order. So you'll have to show the court why this prior ruling is no longer in the best interest of the child or children. Now, there is another thing that you can do. If you and the other parent or the other party who is seeking custody of the child or children have a consent agreement, meaning that you have agreed to change the order because it fits better in your schedule, both of you have had some changes or things have happened, the court may modify the case based on your consent agreement. However, do be aware that the court will be reviewing your consent agreement and can deny your consent agreement if it does not meet the standards. So if there's been some sort of change in work schedule, the court can deem that as a modifiable substantial material change. In the circumstances, if you all come to a consent agreement between the parties. However, the court will also look at whether the agreement you all have made is in the best interest of the child. So even if you agree, if the court deems that the agreement that you have made to not be in the best interest of the child or children, the court can still deny the order. Courts generally will go along with consent agreements as long as you haven't done something that is totally against the public policy of the courts. And generally that would be something that might harm the child. In other words, best interest factors again come into play here. And you want to make sure that whatever decisions you've made between yourselves do take in consideration, is this in the best interest of the child? It can't be about just what's best for you and the other party. It has to also be best for the child. Okay, another consideration is that there are protective orders that modify custody without going back to the circuit courts in Maryland. So custody orders may be temporarily modified by a protective order without the same formalities of a custody modification case. What this means is that if you can show that you or the child are in danger to the extent that a custody order is needed in your protective order case, the district court or the circuit court, whichever court is hearing it, may enter in a temporary custody arrangement which either decreases or denies completely the abusing party access to the child. So in other words, it cuts off the abusing party's access or limits that party's access or significantly alters the access in order to ensure that the parties aren't abusive to one another in front of the child. So it may be the same type of access they have to the child. So if they had them for 1 week on, 1 week off, they may still have the 1 week on, 1 week off schedule. However, there may be some other things in place like supervision during visitation time or supervision during the exchange or exchanges being managed by organizations or by other individuals known to the parties, but where the individuals are not meeting each other to avoid any type of domestic dispute occurring in front of the child or children. Keep in mind that these orders are intended to be temporary. So if you get one of these orders through the protective, if you get like a custody modification through a protective order, you should consider taking it to the circuit court and using that to help you modify your prior custody arrangements. Otherwise, this is a temporary order and the other party may be able to ask that this temporary order be changed back to the original order. So just keep that in mind as you are considering pursuing or defending against custody modification. So that is a brief overview of custody modification in Maryland. If you need more information or if you have questions about this presentation, do give us a call at 240-734-1024 or visit us on the web and allow us to assist you in the future. Thank you for viewing. Have a great day.